do it like 9:30.
Oh,
The
entonces
only option it says is stop live stream.
Oh, okay. Oh, yeah, I did see live on YouTube.
Or should you say okay? And these are the application fields. Sure. Is Rita? She just said okay. Yeah, I'm missing Rita. Okay, yes, she is. Good morning.
Good morning.
Yeah, I have on the screen, Mr. Zuniga, Probation Department, Ms. Briones, Court Reporter, Mr. Mesa, Defense Lawyer, Ms. Salinas, ADA, Ms. Palacios, ADA, and myself. And this is a C-1562-20-B, State of Texas versus Roberto Angel Maldonado. Mr. Mesa, this is your motion, is that correct, sir?
That's correct, Your Honor.
Okay, what do you have?
Your Honor, on this case, these are two cases. Actually, there's three. One's a misdemeanor, but the writ that I filed is on a motion, or actually a writ for bond reduction on the sexual assault of a child, set at 150,000, and enticing a child away, I believe, from parent or guardian at $100,000, Your Honor, on both of these charges that he's got at this point.
Okay. Ms. Palacios or Salinas?
Yes, good morning, Your Honor. Hope Palacios present on behalf of the state.
Good morning.
Good morning, Your Honor. How are you doing?
Good.
Judge, the state's opposed to any type of bond reduction. If I can give the court a bit of history on this particular defendant, Judge. At the time this new offense was committed, the defendant was out on PR bonds on two cases. One of them was an indecency with a child by contact. One of them was an indecency with a child by exposure. Both victims, Your Honor, were alleged to have been under the age of 11 at the time the offense was committed. The defendant was placed on AIP as well. Subsequent to being released on a PR bond, Judge, he picked up these additional charges. And again, we would argue the fact that he was on AIP, not to mention the fact that during the time the offense was committed, he was, well, there was a county imposed quarantine as well, Your Honor. In terms of the specific facts, I won't go into them too much, Judge, but when he was approached by law enforcement, he was in a parked vehicle with a minor. He provided a false name and date of birth to local law enforcement. Subsequent to that, he was arrested for that failure to ID, and the victim, who was under the age of 17, Judge, did make an outcry of sexual abuse. Okay. In addition to that, Your Honor, Edinburgh PD has two outstanding arrest warrants for the defendant related to this particular victim. In addition to that, I've had contact with law enforcement with Edinburgh Police Department. There are two additional victims that have come forward with allegations against this defendant. Okay. And so we point to, Your Honor, we'd ask that the court take into account the nature and circumstances of this particular case, as well as we'd ask that the court take into consideration the future of the community as a whole. And we're opposed to any type of bond reduction.
Mr. Mesa?
Your Honor, I believe, first of all, the purpose of a bond is obviously not to keep somebody in jail. And that would be obviously my first point. Even at the amounts that they're set at this point, he's not going to be able to make a bond. And as far as the outstanding warrants and the additional, I guess, additional victims, those still need to be processed up to this point. Now, lifelong resident, obviously, of the county. I know he had been on AIP before on two other prior cases. And some of those, as far as the outcries, were, from what I can remember, as far as the facts on some of those, that they'd occurred later on at a certain point in time, you know, years after. And so as far as the victim, or the alleged victim, at least on this one, I believe she's at 16 years of age at this point. So my request obviously would be the court to consider lowering the bond. You know, he appeared to all his hearings, even while we were waiting for the old cases to come in. As far as the flight risk, I think on the set charge that when he had been placed on AIP before, he surrendered himself. And so I think those things need to be taken into consideration, as well as the ability for the family to be able to make the bond. And that would be my request, is at least the reduction of bond, at least on the first one, Your Honor, sexual assault of a child. The court would consider a $50,000 cash or surety. And on the enticing a child, that would be the second one that I've got. I'd ask the court to consider at least a $20,000 bond. And even then, Your Honor, like I'm saying, I've spoken to family extensively. Obviously, it's the parent, the mother. They're probably not going to be able to make the bond even at that point. But, you know, in an effort to try to prepare a defense, obviously, then that would be my request at this point, Your Honor.
Did I set the prior PR bonds in the AIP condition, or was it somebody else?
That was a different court, Your Honor.
I'm sorry?
Yes, Your Honor.
It's not Your Honor, it was out of another court.
It was Judge Yanez, Your Honor, if I remember correctly, where she set the bonds, the PR bonds with AIPS conditions.
Okay. I have never refused to lower a bond, but I think I am today, Mr. Mesa, based on the history given to me by Ms. Palacio. So I'm going to deny the request to lower the bonds at this time.
Yes, Your Honor.
All right. Anything
Yes,
else?
Your Honor.
Okay. Thank you all very much.
Thank you,
Your Honor.
Judge.
Thank you.
May I be excused, Your Honor?
Yes, sir. Thank you.
Thank you, Judge.
Thank you.
Thank you, Judge. Have a good day.
You too.